Good day, everyone. Today, I will be discussing another mode of extinguishment of obligation, and that is confusion or merger under Section 4. So, the first article under this section is the Article 1275. The obligation is extinguished from the time the characters of creditor and debtor are merged in the same person. So, as what I have said earlier, we will be discussing the confusion or merger. So, what is confusion? So, it is the meeting in one person of the characters of creditor and debtor with respect to the same obligation. So, if the same person becomes both the one who owes and the one who is owed for the same obligation, which is the creditor and debtor, the debt is extinguished because you cannot owe money to yourself. Like, for example, you borrow money from your parent. So later, imong parent is namatay and you inherit their estate, which includes the right to collect the debt. So now, you are both the creditor and the debtor. Since one person cannot owe money to themselves, the obligation is cancelled. Now, there are reasons or bases for confusion. So the first, the law treats confusion or merger as a mode of extinguishment of obligation kasi parang it would be absurd since a person cannot claim payment from himself. Ayun kasi para siyang in his person became the debtor and the creditor at the same time. So the law recognizes that it is pointless and illogical for someone to enforce a claims against themselves. If the debtor and creditor are the same person, so there is no one to demand payment from or pay to. Hence, the obligation is extinguished because it serves no purpose. So the second basis is furthermore, when there is a confusion of rights, the purposes for which the obligation may have been created are deemed realized. So obligation exists to ensure that specific duties or agreements are carried out. So when confusion or merger happens, the need for enforcement disappears because the person has complete control over both sides of the obligation. Like for example, if ang obligation sa isa ka tao is magbayad og utang, so the purpose is already realized because the creditor and debtor are one in the same person. So, in essence of reason of confusion, it acknowledges that obligation become meaningless when rights and duties converge in a single person. So for confusion or merger to be valid as a mode of extinguishing an obligation, the following requisite must be met. So the first requisite is it must take place between the principal debt and creditor. So kailangan yung subject ng obligation is between the principal debtor and the creditor. So otherwise, if the confusion or merger will take place between the principal debtor and another creditor which is not the creditor of the subject of the obligation, then confusion and merger will not take place. Kasi dapat si debtor and creditor sila each other in one obligation. So, kung iba yung obligation na pinag-uusapan, so hindi yun confusion or merger kasi dapat debtor and creditor kayo sa isa't isa. And yung character ng debtor at creditor ay nag-merge in one person. It's either merge as a person, a principal debtor, or not merge as a personal principal creditor. So, depende yun siya. So the second requisite is it must be complete. So meaning to say, if 10k yung obligation, so the confusion or merge must be equivalent to 10k. So otherwise, if dili siya kompleto, therefore partial lang yung extinguishment ng obligation. Meaning to say, if pila ang nahibilin, so they are still effective, but wala siya nag-extinguish by confusion or merger. So I have an example for the Article 1275. So for make it understand. So, for example, D owes C 10,000 pesos for which the executive a negotiable promissory note in favor of C. So, si C gi-endorse niya ang note to E, who in turn endorse it to F. Now, si F nagpalit og goods from the store of D. So, instead of paying cash, so si F pwede niya i-endorse ang promissory note kay D. So, meron kasi tayo What is, for example, what is negotiable promissory note? So meron kasi tayong sa batas na yung promissory note ay pwede mo yun i-endorse sa ibang tao. Meaning to say, pwede mo siyang ibenta yung pwede mo ibenta yung promissory note based doon sa value na naka-indicate doon. So like for example, nakabutang dito is 10k. So pwede nimo siya ibaligya to another person o 9,900 pesos. So ang 100 anak ka it serve as kita or ginansya sa promissory note nga imong gi-endorse. So you can endorse that if the promissory note is negotiable and that is valid sa batas. So let's go back to the example. Si D may utang na 10k kay C. Now, yung proof ng utang is through negotiable promissory note na in-execute ni D over C. Ngayon, si C need niya o kwarta. So hindi pa nang mature yung promissory note. So in-endorse niya kay E. So in terms, si E di na niya kayang hintayin yung maturity. So in-endorse niya kay F. Tapos si F naman is nagpalit siya og tinda kay D. Now, si D na ang nagagunit sa promissory note. So siya na ang na-I right, meaning to say, the character of the debtor is now in D. And take note, D is the debtor. So here, D owes himself. Consequently, his obligation is extinguished by merger. Now, let's proceed to Article 1276. Merger which take place in the person of the principal debtor or creditor benefits the guarantors. Confusion which take place in the person of any of the latter doesn't extinguish the obligation. So in this article talks about the effect of merger on guarantors. So again, accessory follows the principal. So meaning, if nagkaroon ng merger sa principal obligation, so yung accessory obligation is also extinguished. So yun yung sinasabi dito sa Article 1276 because the guarantees actually an accessory obligation. Pero take note, sa second sentence, sabi dito na yung confusion which take place in the person of any of the latter doesn't extinguish the obligation. So pag yung merger or confusion takes place in person of any of the latter doesn't extinguish the obligation. So if it take places in the person doon sa accessory obligation like a guarantor, so it doesn't extinguish the obligation. Like for example, Mervin owes Earl 500,000 pesos. Tapos the guarantor kay si Eugene. And Earl assign Nicole the credit. And dito si Nicole i-assign na po niya kay Mervin. So here, the obligation is extinguished and Eugene was released from her obligation as a guarantor. Bakit? Kasi dun sa principal obligation, nagkaroon ng merger. So that is consistent to Article 1276. Pero if ang nahitabo is si Nicole, i-assign niya sa guarantor nga si Eugene, so here, the contract of the guarantee is extinguished pero hindi kasama yung principal obligation ni Mervin to pay 500,000 kay Earl. Next is Article 1277. Confusion does not extinguish a joint obligation except as regards the share corresponding to the creditor or debtor in whom the two characters concur. So this provision talks about the merger in joint obligation. Example, si Baby Jane and Queenie jointly owes Alexander 500,000 pesos evidenced by promissory note. So if Alexander endorsed promissory note to John and then si John i-endorse niya ang promissory note dito kay Queenie. So yung share ni Queenie is extinguished pero yung share ni Baby Jane andun pa rin kasi nga sa joint obligation the debts are distinct and separate to each other. So there is no confusion or merger and Baby Jane is still liable for 500,000 pesos. And if sa solidary obligation naman, if like for example is if so they are both obligated or they are both still liable. Kung maskin pagbayad nakabayad na ang isa sa iyahang part pero joint ang nakabutang diri is solidary obligation ma'am. So ang pikas part gapon is nagapon siya obligation. So balik kamong duwa nagapon obligation until nga matawag ni until nga bayaran ninyo tanan, so the obligation is extinguished. Now, let's proceed to Section 5, the compensation. So, under this section, it includes the Article 1278, the compensation shall take place when two persons in their own rights are creditors and debtors of each other. So, what is compensation? So, it is the extinguishment to the concurrent amount of the debts of two persons who in their own rights are debtors and creditors of each other. So, yung compensation daw is nangyayari when two people owe each other money. So in their debts cancel each other out to the extent of the smaller debt. So it's like offsetting the amount they owe each other. So only the remaining balance need to be paid. So we will learn later how this kind of mode of extinguishing obligation works. Because si Lily nangutang og 1,000 pesos kay Norhana. So on the other hand, Norhana owes Lily 7,000 pesos. So both debts and payables are due and payable today. So here, in this particular example, Lily and Norhana can offset or can compensate the respective obligation. So since si Lily is indented siya to Norhana for the amount of 1,000 pesos and Norhana is indented to Lily 7,000 pesos. So they can compensate their respective obligation. So ang mangyayari dito, since Norhana is na siya utang 7,000 pesos kay Lily, so ang babayaran na lamang ni Lily kay Norhana is 3,000 pesos. So that is how compensation works in extinguishing the obligation. So let us distinguish the compensation and confusion. Remember, earlier we discussed the confusion or merger. Now, let us learn what are the difference between the two. So first, in compensation, there are two persons involved. So we have the creditor and the debtor. But in confusion, take note that there is only one person that is involved, who is the creditor and debtor of himself. Kaya nga may confusion or merger of rights or nagmerge kaya nga yung character ng debtor at creditor ay iisa in one person. So second, there are two obligation in compensation and sa confusion naman ay isa lang. So in the third, compensation, there is indirect payment. So although there is an actual payment, kumbaga mag-offset yung kanilang obligation. So they're extinguishing of obligation by indirect payment. While sa confusion naman is nagiging extinguish yung obligation because of impossible payment. So yun yung mga difference between the confusion and the compensation. So now let's proceed to the kind of compensation. So by its effect or extent, the compensation may be total when the obligation of the same amount and are entirely extinguished. Kasi nga, same amount and same obligation. Kaya mag-extinguish talaga siya. So while sa partial is not the same because there is different amount and there is balance. There is different amount, so there is different obligation. So naadyo'y balance nga mabilin. So by its cause and origin, the compensation may be legal. So what is the meaning of this? So by operation of the law, even without the knowledge of the parties, meaning kahit na hindi mag-agree yung both parties, in compensation, mag-automatic yun mag-compensation by the operation of law kasi nga that kind of compensation is said to be legal. Next is the voluntary. So kapag nag-agree yung both parties na sige, i-compensate na lang natin yung obligation natin. So hindi ko na babayaran hindi na ako maniningil ng utang sa iyo at hindi ka na rin maniningil ng utang sa akin. So there is a voluntary decision. Next is yung judicial naman is when the compensation dito is ordered by the court, while the facultative, so when it can be only set up by the parties. Now, let's proceed to Article 1279. So in order that compensation may be proper, it is necessary that each of the obligors be found principally, and that he be at the same time a principal creditor of the other. And it is necessary that both debts consist in sum of money, or if the things due are consumable, they be of the same kind and also of the same quality if the latter has been stated. It is necessary that that the two debts be due, and and they be liquidated and demandable. And the last one is, it is necessary that over neither of them there be any retention or controversy commenced by person and communicated in due time to the debtor. So I have an example here sa first requisite. So that each of the obligors be bound principally, and that he be at the same time a principal creditor of the other. So for example, si Ria Bell nangutang kay Marieta og 10,000 pesos, and si Ria Bell nangutang po siya og 10,000 pesos kay Marieta. So both due and payable today, and Angela is the guarantor. So yung compensation is mag-take place lang between kay Ria Bell and Marieta, kasi sila yung principal debtor and creditor of each other. If Marieta to Angela or Ria Bell to Angela, hindi pwede, kasi si Angela is a guarantor and isa lang siyang accessory ng dahil accessory lang ang kanyang obligation, hindi principal. So for the second requisite, for the example of the second requisite, Omikara owes Chaska the amount of 10,000 pesos. So si Chaska napod siya nangutang po siya kay Mikara og computer worth 10,000 pesos. Both debts are due and payable today. So in this example, remember, sabi ko sa inyo na kailangan yung both debts dapat sum of money. If hindi man pera, dapat consumable siya. If that is consumable, of the same kind, of the same quality. So ang utang ni Mikara is pera. So yung utang ni Chaska is computer. So ang sabi sa batas, dapat yung pera, kung pera din yung ibayad. But here sa example, kay they have different obligation, so the compensation is not proper case even if the both are due and demandable. So for the third requisite, I have an example here. So Kenneth owes Loida the amount of 10,000 pesos due today, and Loida owes Kenneth the amount of 10,000 pesos due next month. So kailangan bayaran ni Kenneth yung utang niya kay Loida na due today, and di pwede na paabutin pa niya next month dahil next month pa naman yung due ni Loida sa utang ni Kenneth. Next is the example of fourth requisite. So Mitch owes Jamaica the amount of 10,000 pesos, and Mitch owes Jamaica the share of the latter in a business, so the amount of which is still to be uncertain. So both debts are due today. So kahit na nag-due yung utang nila parehas, dapat magkahiwalay yung share nila sa business. So dapat kung hindi pa nag-liquidated, so you cannot compensate both obligation. So for the example of fifth requisite, Andrew owes Brenda the amount of 10,000 pesos, and Brenda owes Andrew the amount of 10,000 pesos. Both are due today. Brenda also owes Carlo 10,000 pesos. So Carlo causes the garnishment of the credit of Brenda against Andrew and notifies Andrew not to pay Brenda 10,000 pesos, as Carlo has a better right to the said amount. So normally, Andrew and Brenda debts would cancel each other out through compensation, so extinguishing both obligation. However, since si Carlo garnished Brenda right to collect from Andrew, compensation cannot occur. So Carlo now has a better right to Brenda's credit from Andrew because it is legally attached to satisfy Brenda's debt to Carlo. So ang mangyayari dito, si Andrew must pay Carlo the 10,000 pesos instead na si Brenda. So Brenda debts to Carlo is reduced by the same amount, but Brenda still owes Andrew 10,000 pesos as compensation no longer applies. So now, let's proceed to Article 1280. Notwithstanding the provision of the preceding article, the guarantor may set up compensation as regards what the creditor may owe the principal debtor. So meaning that a guarantor can use compensation to reduce or cancel their obligation to the creditor if ang creditor is nangutang o kwarta kay principal debtor. Like for example, si Mona nangutang kay Lisa og 1 million pesos, and the guarantor here is Mark. So guarantees so guarantees this debt. So si Mark, so if Lisa owes money 300,000 pesos kay Mona, Mona can use compensation to reduce his liability to Lisa by that amount. So as a result, Mona will only be liable for 700,000 pesos kasi yung nadidak siya sa utang niya kay Lisa nga 1 million pesos. So 700,000 na lang ang iyahang mabayaran. So this protects the guarantor by allowing them to offset the creditor's debt to the principal creditor against the guaranteed obligation. Now, next is the Article 1281. So the compensation may be total or partial when the two debts are of the same amount. So there is a total compensation. So yung compensation can either fully or partially cancel out debts between two parties. So depende yun siya whether ang amount are equals or not. So like for example, sa total compensation is nangyayari to when two debts are equal in amount. So the entire obligation is cancelled. Like for example, si A is nangutang kay B og 10,000 pesos and si B nangutang pud kay A og 10,000 pesos. So the debts cancel each other entirely. Neither party owes anything. Then next is a partial compensation. Is nangyayari ito siya when two debts are not equal in the amount. So kung gamay ang utang is dili siya ma-cancel entirely just because naman siya remaining balance that must still be paid. Like for example is si Joy nangutang kay Marjorie og 10,000 pesos, then si Marjorie nangutang kay Joy og 6,000 pesos. So dili siya equal. So after the compensation, the 6,000 is cancelled and ang mabayaran na lang ni Joy is kay Marjorie kay ang remaining 4,000 pesos. So nasabtan. So next is the Article 1282. The parties may agree upon the compensation of debts which are not yet due. So normally, yung compensation is hindi lang siya na-apply sa utang that already due. However, in this article, it allows the party to mutually agree to compensate debts even if those debts are not yet due. Like for example, is si Mayan nangutang kay Paler og 10,000 pesos due in 30 days. Then si Paler nangutang kay Mayan og 8,000 pesos due in 20 days. So even though the debts are not yet due, si Mayan ug si Paler agree to compensate their debts now. So after compensation, si Mayan will still owe B the remaining 2,000 pesos and both parties are free from the rest of the obligation. So nganong 2,000 pesos? So kay si si Mayan naman siya utang kay Paler o nga 10,000 pesos, then si Paler nangutang og 8,000 pesos kay Mayan. So if i-deduct na nimo siya, 2,000 pesos na lang. So that is si Paler mo na ang remaining balance na lang nga iyahang mabayaran kay Mayan. Si Mayan is mauna lang na iyang mabayaran kay Paler if both parties are agree and free from the rest of the obligation. And these articles allow compensation to take place earlier than usual if both parties agree, making it a practical solution for resolving obligations. So let's proceed to Article 1283. If one of the parties to a suit over an obligation has a claim for damages against the other, so the former may set it off by proving his right to set damages and the amount thereof. So in this article, so it allows a party involved in legal dispute over an obligation to use a claim for damages as a form of compensation against what they owe the other party. So they must prove the right and amount of damages. So the party can offset the amount they owe the other party with the damages they are entitled to, effectively reducing or eliminating their obligation. Like for example, kay si Mitch nangutang kay Jamaica og 50,000 pesos, then si 50,000 pesos. Then si Jamaica naka-damage kay Mitch og property causing 30,000 pesos in losses. So si Mitch can claim 30,000 pesos as damages against Jamaica and use it to partially offset the debt. So after the setup, si Mitch will only owe be 20,000, will only be Jamaica 20,000 pesos. So next is the Article 1284. When one or both debts are rescissible or voidable, they may be compensated against each other before they are judicially rescinded or avoided. So meaning diri nga article is gina-allow niya ang compensation na mag-take place even when one or both debts are rescissible or voidable, that are provided that the debts have not yet been legally rescinded or avoided. Rescissible means like pwede siya ma-cancel due to certain legal grounds, while yung voidable naman is valid siya until annulled. Like for example, si Mikara nangutang kay Cheska og 50,000 pesos under a contract that may later be annulled because Mikara signed it under duress or voidable. So si Cheska nangutang kay Mikara og 13,000 pesos for another transaction. So si Mikara and Cheska can offset their debts through compensation, resulting in Mikara is still owing Cheska 20,000 pesos. So even if the court later rescinds or voids, ang obligation ni Mikara is the compensation remains valid for the period before the judicial decision. Let's proceed to Article 1285. The debtor who has consented to the assignment of rights made by a creditor in favor of third person cannot set up against the assignee the compensation which would pertain to him against the assigner, unless ang assigner was notified by the debtor at the time he gave his consent that he reserved his right to the compensation. If ang creditor communicated the cession to him but the debtor did not consent thereto, the latter may set up the compensation of debt previous to the cession, but not of subsequent ones. So if ang assignment is made without the knowledge of the debtor, he may set up the compensation of all credits prior to the same and also latter ones until he had knowledge of the assignment. And this provision explain how compensation work when a creditor assigned the right to collect a debt to a third person. Like if the person consent to the assignment, notified but did not consent or unaware of the assignment, like for example is si Andrew owes Brenda 10,000 pesos and si Brenda naman is nangutang kay Andrew og 8,000 pesos. So si Brenda assigned her right to collect from Andrew to Carla. So if Andrew consent, Andrew can only use his 8,000 pesos compensation if he informed Brenda when consenting that he reserved his right to offset the debt. So if si Andrew naman is notified and wala siya consent, so Andrew can use the 8,000 pesos compensation because it arose before the assignment, but he cannot offset future debts. And if si Andrew naman is wala siya kabalo pero nga naay assignment, so Andrew can use the 8,000 pesos and any of the credits that arose before or shortly after until nga makabalo siya sa assignment. So where the compensation has taken place after assignment, so discuss na ako ni ganina and na ako yung mga na-dictate nga example. So the first is the debtor's consent to the assignment. So what the meaning of this? The debtor cannot use compensation against the assignee unless they are informed the assigner that they were reserving their right to compensation. If the debtor was notified but did not consent, so the debtor can use compensation for debt that existed before the assignment but not for debts created afterwards. So if the debtor was unaware of the assignment, the debtor can use compensation for all debts that arose before they learn about the assignment, including na doon yung mga incurred after the assignment but before they were notified. Now, next is the Article 1286. Compensation takes place by operation of law, even though the debts may be payable at different places, but there shall be an indemnity for expenses of exchange or transportation to the place of payment. So, yung compensation dito is nag-occur siya automatically, even if the debts are payable in different location, but fairness requires that any cost to align the payment are reimbursed. Like for example, si Andrew owes Brenda 10,000 pesos. For example, si Andrew owes Brenda 10,000 pesos payable in Manila, while Brenda owes Andrew 10,000 pesos payable in Cebu. So the compensation here is yung utang nila is nag-cancel each other out. So but if Brenda must send the money to Manila or Andrew to Cebu, the party incurring the expenses. So nasabtan. So Article 1287. Compensation shall not be proper when one of the debts arises from a depositum or from the obligation of the depositary or of a bailee in commodatum. Neither can compensation be set up against a creditor who has a claim to support due by gratuitous title without prejudice to the provision of paragraph 2 of Article 301. So Article 1287. So specify situation where compensation is not allowed, depositum and bailee obligation. Compensation cannot use to offset debts arising from safekeeping or lending of the goods or depositary bailey's duties. Like for example, si Andrew leaves a valuable item with Brenda for safekeeping, which is the depositum. So Brenda owes Andrew 5,000 pesos and Brenda cannot use the 5,000 debt to offset her duty to return the item to Andrew. So, for claim for support, the compensation cannot set up against a creditor who is owed support such as child or spousal support due to moral and legal duties. Like for example, a parent owes monthly child support for 10,000 pesos to the child. So the child owes the parent 2,000 pesos and the parent cannot reduce their child support obligation by using child's debt for 2,000 pesos. However, there is an exemption for reciprocal support claims under Article 301, Paragraph 2. So, Article 1288. Neither shall there be compensation if one of the debts consists in civil liability arising from a penal clause. So it states here that the compensation cannot be applied if one of the debts arises from civil liability resulting from a penal clause. So yung legal compensation is not allowed in the following instances: debts from depositum or bailee obligation. So when one debt arises from a deposit or a bailee's obligation, the obligation to return the item takes precedence over compensation. So for claim for support, the compensation cannot be applied to debts related to support, as these are based on moral and legal duties. So for civil liabilities from penal clause, so if one of the debts arises from civil liability due to criminal offense, compensation is not allowed. A person cannot offset criminal liability with other debts. So with other debts. So the last one is debts in reciprocal contract. If the obligation arises from the contract involving reciprocal duties, compensation is not allowed unless both debts are due or one party's performance is already due. And these restrictions ensure that certain obligations, especially those tied to moral or legal duties, are not easily cancelled through compensation. So Article 1289. I'm sorry guys na mali og type ang naa sa PPT. So mao ni siya ang complete complete provision sa Article 1289. So a person should have against him several debts which are susceptible of compensation the rules on the application of payment shall apply to the order of the compensation. So in this article, it ensures that when multiple debts are involved, the order of compensation follows the same rules as the application of payments. Like for example, John owes Mary 10,000 pesos which is due today and 5,000 pesos due in 30 days. So Mary owes John 12,000 pesos due today. So compensation will first apply to the 10,000 pesos debt since both debts are due. Yes, both debts are due today, and then if any balance remains, so it can be offset the next debt. So for Article 1290, when all the requisites mentioned in Article 1279 are present, compensation takes effect by operation of law and extinguishes both debts to the concurrent amount, even the creditor and debtors are not aware of the compensation, meaning it confirms that the compensation happens automatically when the conditions are met and both debts are extinguished to the amount of the smaller debts, even if the parties are unaware. So I have an example here for Article 1290. So Anna owes Beth 15,000 pesos and Beth owes Anna 10,000 pesos. So the debts are automatically offset each other and Anna will only owe Beth 5,000 pesos. So this happens even if Anna and Beth are not aware that the compensation has taken place, as long as the legal requirements are met. So this is the end of my report, guys, that hope you understand my topic for this, for the start for Article 1275 to Article 1290, which is under of two section, the confusion or merger of rights and the compensation. Thank you.